that 7 provisions were actually preempted by ERISA. And it's interesting to see what those 7 provisions were. They included what they were referred to as anti-discrimination requirements, that is discriminating against pharmacies. The any willing provider standard that was in Iowa law was preempted. The open access standard for specialty drugs was preempted. The mail order pharmacy and cost sharing provisions were preempted. The deductible credit requirements, the mandatory contract terms and suppression provisions were prohibited, and the general enforcement provisions, which were not enforced by the Iowa Insurance Division, but rather there was what we call a QI-TAM provision that allowed civil lawsuits and allowed individuals to file suit with regard to the provisions. Those were all things that were found to be prohibited. Other provisions, such as limitations on guidance to preferred pharmacies, a dispensing fee provision, and various reporting and transparency provisions, which I can go into if you want, were all found not to be preempted by ERISA. And in addition to that, there was one provision that was found to be unconstitutional based on a provision based on First Amendment rights of. So what's the bottom line from all that, right? The bottom line is that, frankly, there's still a lot of murkiness regarding the application of ERISA preemption to the activities of PBMs. But there are some general rules of thumb that can be gleaned. I think first, courts have generally upheld provisions that reflect permissible exercises of state authority over professional licensing, cost regulation, and commercial relationships outside the scope of ERISA. Other provisions, may be permitted by the courts depending on which jurisdiction you're in, to be honest. But no matter what, my advice is that, with regard to any new matter, you're going to have to look at it on a careful case-by-case basis and analyze, the ERISA standard and try to determine whether or not ERISA preemption applies. So that's it in a nutshell. I've gone through an awful lot in just a few minutes. Hopefully, I didn't bore you all to death.
Thank you, Van. We will now open it up. Do work group members have questions? And it might be helpful if you hit the raise hand if we have multiple people with questions. But anyone on the work group? Okay. Steve?
Hello, thank you for taking my questions. And thank you, Van, for the thorough review of the court cases. I have two questions. Can everyone hear me? I'm sorry. Okay. Yeah. Okay. So one was, and again, I'm not an attorney. So I don't pretend to be an expert. I'm not on the law. I seem to remember something in the ERISA cases where state laws that specifically pointed out whether their laws were affected by ERISA or not were sort of frowned upon. The law, and again, I might be completely wrong, but I seem to remember reading somewhere the law should state the law, and it shouldn't say this is ERISA exempt and this is not, which I think a lot of of our Maryland pharmacy and PBM legislation does just that. So I'd like someone to comment on that and correct me, because I really should be wrong, because I know our laws almost segment by segment say carrier or not carrier. They in one way or another, they indirectly say whether ERISA affects that section or not. And the second part is, we have pharmacy and PBM related legislation in Maryland that took many years to haggle over and to pass. And I think the next step, now that we have sort of the current state of the legal cases, is now the next logical step is to pick those sections apart, section by section, and say, based on what we know today, this section wouldn't, in our opinion, is not preempted by ERISA, and this is. Because quite frankly, the pharmacy community will say everything shouldn't be affected. And the payer and PBM community will say, if we put a paperclip on the legislation, it is plan design. And that's what we have year after year after year. It would be a tremendous service to the legislature to finally, chapter by chapter, this section is with audits, and this section is with DIR fees, and this section is with pharmacy and therapeutic committee, and to say our opinion based on looking is this section is not, this section is it is. I would think that is the next logical step of why we're meeting, if we're talking about ERISA and not Medicaid dispensing fees. We're going in this ERISA direction. That's the logical next step, in my opinion. So I thank you for taking my question and comments.
Mary, if you want, I think I can address at least his first question. Can
Okay.
Everyone is able to hear me? So I would quibble a little bit with your phraseology about what the Maryland law says in terms of ERISA. What it does is it states which types of activities are that PBMs are doing, and which plan, and which to whom the statute applies. That's what the statute does. And so, when it says a statute is applies when a PBM is acting on behalf of a carrier, that means it's in the insurance realm. And so that's the purpose of that. But to answer your question specifically, the Supreme Court has said that the reference to provision only applies if, again, if it acts immediately and exclusively on ERISA plans, and none of Maryland laws do that. And with regard to some of the Maryland laws, they may apply to PBMs that are acting on behalf of ERISA plans, but and some of them don't. But in no cases are they exclusively applying to ERISA plans. So the reference to ERISA in the Maryland statute is permissible, and frankly, it's not dissimilar to how how ERISA is referenced in other provisions of the insurance articles, such as with regard to TPAs. So that's the first point. The second point, and I should have mentioned this in my comments. The Iowa opinion that came out in July was actually appealed by both sides. And so while we've got a nice 87-page opinion from the district court from one judge, I can't tell you, as I sit here today, how the Eighth Circuit is going to rule with regard to the Iowa statute. And so I think once we do hear from the Eighth Circuit, And I imagine entities that are on this call probably will be participating in that litigation in some form or another. I think, frankly, the country will have better idea, a better idea of where things stand with regard to, is it a connection with, and is this particular provision applicable? Many of the provisions in the Iowa law are not dissimilar to, what are available in many other states. And, Maryland's not alone. It's actually true that every state in the country has at least some regulation of PBMs in them. And, the NAIC has put out a booklet about some of those, and they list 27 different categories. And I will tell you, there's disuniformity among those, to use that word again, because, for example, the audit requirements that we have in our statute, some states apply those across the board, and some states like Texas only apply those to PBMs that are acting on behalf of carriers.
So would it make sense then, after that Eighth Circuit Court decision, to then reconvene and do the next step that will help the legislature? Because it's a stalemate year after year after year. I think that's part of our charge.
I can't speak for the General Assembly as to when they want this meeting to proceed, but I do think it is true that we will have more information once we get a ruling from that court. Now, will any decision from the Eighth Circuit in that case, then will someone file a petition for writ of certiorari to the Supreme Court? Perhaps. Will the Supreme Court act?
Sure.
Who knows? I can't answer that.
Yes. Okay. Thank you.
Sorry. Yep.
Okay, thank you. Any other members of the work group? And Beverly, I'm sorry you had trouble getting on. I'm glad you were able to join. Do you want to briefly introduce yourself?
Thank you. I'm happy to be here. I am currently the Director of Human Resources for Queen Anne's County Government. And I also serve as the chair for the ESMIC Health Consortium on the Eastern Shore. And prior to that, I was 18 years in human resources with the hospital in Chestertown, Maryland, where I have my affinity, I think, for healthcare. And so I am hopeful to add some value to the committee, and I'm glad to be here.
And thank you. We're happy to have you here too. Okay, Kim, we see you're here. Thank you. If there are no other panelists, Steve, do you still have your hand up, or did you raise it again? Okay. I will then call on people to be moved over, people who signed up in advance, and I have Ray Baker. Okay, if we can move Mr. Baker over.
Good afternoon. I want to thank the work group for the time. My name is Ray Baker. I serve as the Maryland Director for the Baltimore, D.C. Building Trades Council. Just as we opposed the bill during the legislative session, I would advise this work group with as best and most sincere as I can that our union members do not want to lose any of our ERISA exemptions. As we've heard from the conversation here, this issue, whether we're talking at the Supreme Court level or applied at the state, seems to be as clear as the mud outside on a rainy Baltimore day. And since we lack such clarity, and since our union members and their healthcare benefits and their pharmaceutical needs are so thoroughly tied to our ERISA exemptions, we want to stress how important this is to us, how we all are continuing to watch and monitor, and happy to participate in any work group study sessions or anything else that we work through to ensure that our union members, the hardworking folks that are doing important things like rebuilding the Key Bridge, continue to have the protections of their healthcare and pharmacy benefits needs that a union contract and union membership provides. So I want to take this time in our public comment to thank everybody for their work and the sincerity and the authenticity in which they're working with, but stress how committed the building trades are to not losing our ERISA exemptions. And I would like to thank you all for the time and attention in this conversation.
Okay, thank you, Mr. Baker. And apologies if I mispronounce this. It is Rico Albuquerque. If he can be brought over, I don't see him in the participants. So I will move on to Michael Sanderson.
Good afternoon. Thank you all very much for the opportunity to speak today. I'm Michael Sanderson. I'm the director of the Maryland Association of Counties, with some, I think, general points of view on behalf of public employers. Generally speaking, county governments and other public employers need to rely on benefits for our employees to attract and retain folks in public service. As a rule, we end up with strong offerings for benefits. That's an opportunity for employees to secure a public pension and to find healthcare offerings and increasingly prescription coverage as part of their compensation package for public work. It's a big part of our sell for that line of employment. We're different from private employers. We don't have the opportunity to just go out and sell more widgets. And that may make us even more vulnerable to cost pressures than other issues. So I'm not here to speak chapter and verse in detail. I actually learned a lot during the presentation earlier and appreciate the opportunity to listen in on that. But I will say, as healthcare costs are rising for all players, but certainly for employers and in the public sector as well, we have a major challenge to our ability to offer good benefits for our employees. Our concern with ERISA exemptions would be if we open the door to new limits and boundaries on PBMs, it could just threaten a tool that we need to be able to continue giving strong and reliable benefits to our employees as a matter of cost and availability. These are partners who have skills and negotiation ability and so forth that goes beyond what most of our county governments have in-house. We need that kind of partner to help effectively and efficiently provide those benefits. Our self-insured counties would be the principal concern, but I think potentially all of MACO's members and public sector employees generally would share this concern. So that's our point of view on this broad issue. Welcome the opportunity to join you today and share those thoughts, and appreciate the attention you all are paying to an important issue in Maryland. Thank you.
And thank you, Mr. Sanderson. I have Paul Green is next on my list.
Mary, can you repeat that name, please?
Paul Green.
Thank you. You should be able to speak. There we go.
There.
Now can you hear me?
Yes, thank you.
All right. My name is Paul Green. I got to take these out. I was on the phone also in order to avoid the difficulty of the uncertainty of my computer. So I was participating by phone. My name is Paul Green. I'm here on behalf of the National Coordinating Committee for Multi-Employer Plans and serve as its general counsel. The NCCMP is the only national organization representing the interests of plan millions of working people and their families they serve in the labor unions and employers that establish collective bargaining. I'm an attorney with the law firm Mooney, Green, Sand, and Murphy and Welch, and as specialist in ERISA and employee benefits. And I was asked to serve on the legislative committee that designed the Small Business Retirement Savings Plan in order to help them avoid the pitfalls of preemption. And I continue to serve on the board of the Maryland Small Business Retirement Savings Board. The Rutledge decision by the Supreme Court, in my view at least, draws the parameters of federal preemption between those state laws that merely regulate costs and those that significantly interfere with plan design and administration. And a perfect example, I think, of permitted regulation is Maryland's unique system of setting hospital rates, which seems to work very well. It has resulted in some of the lowest rates in the country. On the other hand, many states have seen Rutledge as giving them carte blanche to regulate PBMs without regard to the impact of those restrictions and requirements on self-insured multi-employer plans and their participants, who are the intended beneficiaries of federal preemption. Multi-employer plans typically operate across state lines and lack the resources to have to customize plan design and administration across state lines. One of my clients, for example, a self-insured Maryland Teamsters plan, provides benefits to hundreds of employees who live and work in 3 different states, Maryland, West Virginia, and Pennsylvania, and their families. And the burdens that would be placed on them on plans like these would severely impede their ability to serve the interests of their participants and beneficiaries and drive up their costs, reducing the funds available for benefits. For these and other reasons, I ask that you carefully consider the impact on these plans of any legislation that you recommend and honor Congress's broad preemption of state law under ERISA. And thank you very much for allowing me to speak.
Thank you. And I have Andrew Griffith.
Good afternoon, everybody. Andrew Griffin here, offering comments on behalf of the Maryland Chamber of Commerce. Represent 7,000 plus employers across the state. Our position on moving forward with kind of additional regulation around ERISA, or the removal of ERISA protections, is kind of been well documented. And so some things I'll just mention for the group, I don't think will be groundbreaking, but just to kind of remind you all, the employer community, particularly multi-state employers, what is so important is uniformity in policy and regulation across states. As this is a prime example of something as states begin to kind of move into or out of uniformity of a policy, creates a lot of administrative and cost burden, becomes really difficult to manage employee benefits across states. And so I would just offer that to you all to consider. I would also say, it's no secret, the cost of healthcare continues to rise. And one of the primary tools that an employer has in its toolbox is that flexibility to design the plan that best suits not only their needs and their cost restraints, but also, in conjunction with the employees themselves. Certainly, I'll just, as an observation, I don't know many times where I kind of sit on a call or offer comments where I sit on the exact same side of the table as organized labor or public employees as well. So public employment. So we're all kind of in lockstep saying, if you consider kind of going down this path with additional regulation, it's going to be more difficult for employers to continue to offer the benefits that they do. It's going to become more cost prohibitive to do so. And I think the worst case scenario there is that employers begin to roll back some of the benefits that they are offering because of it. We see it in other programs, and I don't see why this necessarily would be any different. So I appreciate the time and happy to talk offline and answer any questions you all may have. Thank you.
Thank you, Mr. Griffin. Okay, those were the people I had signed up to speak. Does anyone else who is in attendance want to speak? If so, please raise your hand. Delegate Cullison.
You hear me now? Great. Thank you. Thank you, Mary. I appreciate it. And thank you, Van, for that very comprehensive review. I have a couple of questions for Van, actually. One, I want to make sure that I was clear when I heard you say that the one element that the court seemed to have upheld throughout all of these different cases is the cost regulation and the licensing of, I'm assuming it was PBMs and pharmacists. Is that, am I correct in that understanding?
That is correct. As you heard from some of the comments today, everyone agrees that Rutledge applies to costs. And so all of the provisions, generally speaking, the provisions that apply to costs, dispensing fees, things of that nature, those kinds of things have been upheld. Similarly, the licensing of PBMs and the things related to that, as i.e., the inspection and investigation by the regulator, all those type of provisions have also been upheld.
And that includes with respect to the PBMs, right? So
Yes.
the regulator, okay. So the other question I had is I heard you, I actually, I heard you say that there are some elements, and specifically you called out audits, and you named the audit processes, and I think you named that, the laws that we have here in Maryland sort of relate to those that are in Texas. So that is not necessarily a piece that the courts have dealt with necessarily. And so will it be in this Eighth Circuit question that's going forward?
I do not believe so. That wasn't one of the provisions. The Iowa law is very comprehensive. I would have to say that it covers a lot of things. Many of them are cost related, such as pass-through rebates, and their appeal process was upheld. Their external appeal process. So there are things like that that were in that case, but I do not believe the audit provision was. One of the with regard to audit, I will say this: one of the questions is who's being audited, right? And who, what are we talking about? And it's, if it's the, generally speaking, if it's the audit of the pharmacy, that's generally what many of the states have, and those are where the restrictions are with regard to that type of thing. Is that really central to the administration of a plan? I mean, that's the question.
Okay. One last question. Do we have any sense of a timeline for the appeal process for the Eighth Circuit?
I knew that question was going to be asked. And it's on a preliminary injunction, the appeal. So I believe that it will be quicker than it would be if it was a final decision, because both sides are trying. Iowa's trying to get their full statute in place, whereas the other side's trying to get the whole thing thrown out. So I think it'll be quicker than if it was a final decision. That said, the appeals were only filed recently. It takes, say, a schedule to brief it will be several months, because each side gets at least 30 days to review, and it may be longer than that. And then there'll be replies and surreplies, given that both sides are appellants in this case. So that'll take a couple months, and I couldn't tell you when they're going to set it for argument.
Okay.
Will it be early next year? I don't know. Certainly I'll be checking the docket.
Okay, great. Thank you, Vanna. Thank you,
Yep.
Mary, for letting me jump in.
Thank you. Brian.
Thank you. I know that we've heard several times from the employer groups and groups that represent group health benefits programs, and I've always wondered why when we hear from these folks that there's never any comment on the transparency provisions in Maryland and whether they believe that they would be helpful to them, because I feel like some of the PBM transparency provisions would allow these folks to better analyze the plans that they have. The amount that they're paying these folks, these PBM middlemen, and we've seen all over the country when people take a hard look at what's going on, they're finding all of these dollars that they're spending that aren't doing anything except going to the PBM. So I know that oftentimes this entire bit of legislation is opposed by those folks, but are there some sections in here where they can agree it may be beneficial for them if they got, a good look at, under the hood of what's going on as far as where's the money going within these plans? And then my other comment would be, you can have the greatest benefit design out there. You can have the greatest plan out there. But if all of your providers are out of business because you don't support them being paid fairly and being dealt with fairly by the PBMs, it doesn't amount to anything. No one's got anywhere to go to get pharmacy services. So I think that this is a bigger argument than just insurance might cost more because my PBM is telling me that. We've seen states with strong PBM regulations where costs have gone down. So I think that there's a lot going on here, and it's not always my PBM tells me this is going to raise my costs. So I'm against anything that is put out there that they can attach that to. I don't think that we've seen that in every state where we've seen strong PBM regulation.
Okay, thank you. Aaliyah?
Hi, good afternoon. I just wanted to share that, the underlying goal of the legislation that's been put forth year after year is to ensure that patients have access to pharmacy services. And I think, Brian was looking at my notes, even though we're halfway across the state, in that you can provide benefits and want to offer the best benefits, but it serves no point if the patient doesn't have access to those benefits. And we've heard that if pharmacies close, patients can just go to mail order and that sort of thing. But as employers and those representing employers, you need to understand that there are schedules of medications that can't be delivered via mail order. And I think about those folks in the trades and working in more labor intensive arenas when you're talking about pain management. Those are medications that need to be worked with a medication expert, with a pharmacist, and we're losing those people. And I would like to think that we can come to some sort of resolution or agreement to address some of these issues so that patients can have access and the people that need to provide the access and services are available. So, I hope we can get to something for this legislative session. So thank you.
Okay, thank you. We are drawing close to the end of the hour, but I see Stephanie Katz has a hand up if she can be moved over.
Oops, and apologies. I hope I didn't just become a panelist. I will undo that. So sorry. Just to echo some of my colleagues, I really obviously appreciate where the employer groups are coming from here, but we spend a lot of time battling PCMA. Their general idea when we are in these meetings with them is if you regulate the PBM industry in any way, it's going to hike up your premium costs and you are going to lose benefit design for your folks. And while I appreciate that idea, the question then is why? When we have the FTC indicating to us that we have a multi-billion-dollar industry just in the form of specialty drugs, an $8 billion profit margin, The question is, why would providing a pharmacy with, at the very least, the cost of their services, their cost to provide services, raise premiums? Well, I think we need to ask ourselves why we're not talking about the vertical integration between that PBM and that insurance plan and how that's affecting employer plans. And can we look at a way to respect the ERISA provisions that are at debate here, right? And still say, how do we put some teeth behind these laws? Because the other part of it is we aren't seeing a lot of teeth in most of the state laws. So how do we ensure the provision of these pharmacy services while respecting the ERISA regulations, ensuring that we're working with employer groups, but also acknowledging the fact that, you know, one of our colleagues here today said, well, these people are doing a really big piece of negotiation that I can't do. I would just say, I would challenge that. What is that negotiation that's happening? Because the negotiation is on the benefit of the PBM. They are extracting billions of dollars from the system for a reason. And it's really clear when we look at that and when the FTC looks at that, that they're extracting that off the backs of those employers and those patients. So the other thing just to say is mail order. You know, our colleagues mentioned that earlier. Pharmacies are providing a really comprehensive service on the ground. We are providing vaccine services, issues with diabetes services, blood pressure services, depending on the state, right, and state scope issues. They're finding these pharmacy services are saving billions of dollars. And there are some studies indicating that over the long term, they will save trillions of dollars. So don't look at pharmacy services in the vacuum of just drugs. We want to make sure these pharmacies are staying open, because it's not the pharmacy service that's going to pull your premiums up. It's going to be perhaps your diabetic employee, folks like that are going to end up in the hospital. And that is when this gets very expensive. And you will find that pharmacy services, when comprehensive and responsibly accessed, are able to pull down those other pieces of healthcare and pull those premiums down. So just to say, I don't know that pharmacies are the ones that should be paying that extra premium. We want to keep these folks open to keep your employees healthy. And there's probably a way for us to work together more comprehensively to make that happen.
Okay, thank you. Mr. Glasscock.
Sorry, it wouldn't let me unmute, but I think there has been several great comments here. But I think you look at the situation, the PBMs, we're on this panel, we have the employers kind of addressing the pharmacies, talking about not increasing costs. But if you follow the money trail and you look back over the last 2 years, the number of pharmacies that have went out of business versus the number of PBMs that have went out of business. So the margins within the pharmacy business and the margin within the PBM business are obviously at stark contrast, because the pharmacies are not going out of business because they're making abundance of profit. So I do think it would be beneficial for the employee groups and the pharmacy groups to work together, because obviously from a lot of the reporting and stuff you've seen, there is some wasteful spending. And I think also as these states look at these laws and stuff, they also need to, bring in the consulting groups as part of this regulations and stuff, because I think there's some opportunities within the consultants as well as the PBMs to pull out money of the system, allow pharmacies to continue to service patients, and save the employers and the health plans money.
Okay, thank you. And we have 2 minutes left. I don't see anyone else with a hand up. Our next meeting will be on October 8th, I believe is when we have it on the schedule. And if there are no further comments, thank you, everyone. This has been an interesting discussion, and any further comments can be submitted in writing. And there's the email address. Okay. Do we have another slide? That should be about it. Again, thank you, everyone.